This PowerPoint will compare constitutional rights and process between traditional and white-collar crime. This is based on Module 1, Readings, Part 2. The core question is, how does the rise of stronger constitutional rights for defendants affect prosecutors' decisions? William Stuntz, who you read, notes, prosecutors probably don't charge less because of the law of criminal procedure, but they may charge differently depending on who is most likely to exercise and litigate over their Fourth, Fifth, and other constitutional rights. Developments in the law of criminal procedure over the past 3-4 decades have substantially raised the cost of prosecuting defendants with more money. Clients with the resources to pay for an aggressive defense can take full advantage of the large bodies of Fourth, Fifth, Sixth, and 14th Amendment law that govern the criminal process. But given the low level of funding for appointed defense counsel, the law of criminal procedure has a much smaller effect on the cost of prosecuting the run-of-the-mill armed robbery suspect without the funds to hire a lawyer. Prosecutors then budget in mind that pursuing a rich client is kind of unattractive in that case, since those defendants could take advantage of all the constitutional law defenses and draw out the trial. This has led to the rise in cases where counsel is appointed, now up to 80% compared to a number of decades ago. This reflects the drop in the prosecution of rich defendants. So what does this mean for white-collar defense and these constitutional claims? First of all, the disparate wealth of defendants means disparate investment in constitutional claims. Poor defendants can try to raise the threat of a constitutional claim when doing plea bargaining, and most criminal indictments end up in plea bargains, not in actual trials. But those poor defendants face prosecutors who can outspend them, so defendants usually fold. Appointed defense counsel has to ration time across many cases, leading to under-litigation of those claims amongst poor clients. So more constitutional rights don't really add tools for most poor clients, since they can only litigate limited number, given their defense counsel time, but rich clients who can litigate every single constitutional claim available get great benefit from the expansion in constitutional claims under the Constitution over recent decades. So, what this has meant in practice is most white-collar prosecution has moved from the states and local prosecutors to federal prosecutors and various agencies of the government. State criminal law of fraud, which used to be where most white-collar crime was targeted, has been superseded by federal mail and wire fraud statutes, securities regulation, banking regulation, and so on. Now, you still have a lot of expensive defense maneuvering at the investigative stage, long before charges are even filed. So that's going to cause most state prosecutors to pass. Federal prosecutors don't have to worry about being elected by local populations, and working in agencies set up under specific regulation have more dedicated imperatives to pursue specific kinds of wrongdoing. You know, you also have, out in the states, the rise of civil forfeiture, where even before trial, the assets of a defendant can be seized if those assets were apparently used to commit a crime, such as a drug crime. What that means, though, is folks involved with various kinds of crimes subject to civil forfeiture, even if they had money, may see it seized and denied the ability to pay for a defense, putting them in the class where they need to plea bargain because they just won't have the funds to litigate. What this means is that many of the expansions of defendant rights that were approved by courts in the hopes of ending economic and racial discrimination have sometimes led to the exact opposite. Even as the stated purpose of the constitutional rights in the 1960s was to stop racial discrimination, as constituted, it mostly does not. Because prosecutors retain discretion on who they charge, the discrimination in that choice of who to charge is not touched by constitutional law. Legislatures are also free to punish crimes likely to be committed by poor, non-white people more harshly than crimes committed by richer white people. To the extent that poor defendants are disproportionately non-white, constitutional law, therefore, may encourage more prosecution of them and less of well-off defendants. Given that funding for criminal defense for poor defendants has declined on a per-case basis since the late 1970s, even as litigation costs have increased, the problem has just become worse. So what are punitive damages? The white-collar crimes that are most often targeted are those in civil lawsuits brought by the victims of the crimes demanding compensation and punishment, usually in a financial form, against those who committed the fraud, violence, whatever it was that they're bringing the litigation over. Within that kind of litigation, punitive damages are the award where fraud, malice, or violence is tied to conduct, quote, often prohibited under the penal codes, but where instead of imprisonment, where, since the dilemma is always who goes to jail when it's a corporation as a whole committing the crime, the question is what level of financial punishment is sufficient. Those kinds of punitive damages are treated as quasi-criminal sanctions under this law. Note, punitive damages are separate from what's called compensatory damages, which is simply to restore the specific economic losses of a plaintiff and aren't aimed at punishing the defendant. It's equivalent of if you steal from a store, if you give back what you stole, but we still punish far beyond that. And that's what punitive damages are in the corporate litigation sphere. But here's the thing. The Supreme Court has sharply limited punitive damages in recent decades. There was earlier support for punitive damages under court doctrine. 1989, Browning-Ferris v. Kelko, the court held that the Eighth Amendment, which limits, quote, excessive fines, does not apply to punitive damages. It seemed to be saying, whatever jury said would not be subject to constitutional limits. You had a specific case, Pacific Mutual Life Insurance versus Haslip, which held that punitive damages did not violate the 14th Amendment due process clause. Another case upheld an award of $19,000 in compensatory damages with $10 million in punitive damages, essentially to encourage the same fraud not to happen in the future. However, in the mid-1990s, there was a turn against punitive damages. First major case was Honda Motor Company versus Oberg, which struck down an Oregon statute that had disallowed judicial review of the size of punitive damages awards. The Supreme Court said courts had to have the right to review these awards. Now note, the reason Oregon would have passed such a law is they didn't like the decisions the courts had been doing to actually limit awards. So this was the Oregon legislature saying whatever the juries come up with is what they want to have the punishment be. But the Supreme Court said that kind of open-ended punishment of the corporate defendants was not allowed. BMW of North America v. Gore. This was the first major case that struck down a major punitive damages award. In this case, a $2 million punitive damages award against BMW and said it was excessive and unconstitutional, not under the Eighth Amendment, but under the Fifth Amendment Due Process Clause. And as you did in your reading, you read State Farm Mutual Insurance versus Campbell, which came down in 2003. It struck down a punitive damages award of $145 million, where the compensatory damages to make the victims whole was only $1 million. They said this violated the Due Process Clause of the 14th Amendment, essentially reversing their earlier position. Let's talk about State Farm v. Campbell. The court in the decision cited to the Magna Carta on the horror of, quote, arbitrary coercion, and of other cases where the unconstitutionality of the punishment involved an arbitrary deprivation of property. They noted that punitive damages can vary too much between different juries and therefore be based on bias or whim. And they argued, quote, a defendant should be punished for the conduct that harmed the plaintiff, not for being an unsavory individual or business. But note, a defendant being unsavory or of bad character is built into most of criminal law, but apparently isn't supposed to apply in these corporate defendant cases. The dissent cited to this and argued that the court was making up these constitutional limits on punitive damages that had no real relationship to the text that they were citing to of due process as a general concept. And they cited specifically in this case to the fraud, the destruction of evidence by the company as meriting severe punishment to prevent repetition in the future, much as most criminal law does. So compare that with a different case, Harmelin v. Michigan from 1991. There, the court ruled that life in prison for a drug possession charge did not violate the Eighth Amendment's prohibition on cruel and unusual punishment. Specifically, they said there is no requirement of proportionality between the crime committed and the punishment meted out. The dissent in Harmelin noted the problem of excessive and potentially arbitrary punishments where there was no limit of looking at what the defendant did and what the punishment they received was. And Harmelin would lead within a few years to judicial approval for life sentences for stealing a pizza, a pair of golf clubs, or just a video under many recently enacted 3 strikes laws. And it's hard not to compare the court's constitutional concern about arbitrary and non-proportionate punitive damages awards against corporation, versus its indifference constitutionally to excessive punishment for traditional criminal violations. Now, there are some important differences between civil juries and criminal juries that the reading talks about, but still, there is an important distinction worth focusing on and talking about what the Constitution should do to bring together standards where the poor and the rich, corporations and individuals shouldn't live in such completely different constitutional worlds about the limits on the punishment they face. And yet they do.